Free Billy Tibbetts.
All rise for the court, please. Yea. All persons having business before the Honorable Beverly Kennedy, Justice of the Norfolk Superior Court, in the Floyd County of Norfolk. Give your attendance, you may be seated.
Your Honor, this is 22117, the Commonwealth versus Karen Reed. Can I have counsel identify themselves, starting with the Commonwealth?
Adam Lally for the Commonwealth. Good morning.
Good morning, Mr. Lally.
Good morning, Your Honor. Laura McLaughlin for the Commonwealth.
Good morning, Ms. McLaughlin.
Honor, Alan Jackson on behalf of Ms. Reed.
Good morning, Mr. Jackson.
Good morning, Your Honor. Attorney David Yannetti on behalf of Karen Reed.
Good morning, Mr. Yannetti.
Good morning, Your Honor. Elizabeth Little, also on behalf of Ms. Reed.
Good morning, Ms. Little. Good morning, Ms. Reed. All right.
Can I just have, Mr. Reddington, could you identify yourself for the record?
Sure. Kevin Reddington, I represent Jennifer McCabe.
Good morning, Mr. Reddington. I appreciate you joining us today. I know that you're out of the country. Thank you. All right. So we have 4 sets of motions. The first one that I would like to address.
Free my boy Tipsy.
What was that, Jim?
I don't know what that was.
I think it was somebody on Zoom.
Nobody can speak, so it only could have been maybe. I think we're all set.
All right. So the first motion I'd like to deal with is the defendant's motion for Rule 17 records directed to Jennifer McCabe.
Trap.
Kevin, could you just be either mute or watch us?
Jim, that's not me. It's somebody else is saying, free my boy Billy Tibbetts. That's not me.
Okay. Thanks, Mr. Reddington.
Thanks.
Go ahead, Mr. Jackson.
Kevin, that was you.
Good morning, Your Honor, and thank you for giving us the time to address the court on these summonses for the third-party communications. I think I can cut this relatively short, given the Commonwealth's position that they are in agreement that the summonses for these third-party communications should issue. I want to save some court time.
Billy's innocent.
All right, so we may have to cancel Zoom for everybody if this keeps up. We will have to cancel Zoom for everybody if this keeps up.
I think I got that person, but
Fuck off, Beverly.
maybe I didn't.
Go ahead, Mr. Jackson.
Thank you, Your Honor. I want to try to save some court time and judicial resources. If the court is inclined, given the Commonwealth's position that they are in agreement with us to issue the summonses, I'll just submit on the papers and be done.
I have third parties that need to be heard.
If the court wishes, I'm happy to address the third party concerns once they are heard.
No, I'll hear you now.
In terms of the papers that were filed, and my understanding is Mr. Reddington joined on Ms. McCabe's behalf with Elizabeth Proctor's motion and her position filed by her counsel. It basically comes down to a singular issue, and that is one of privacy. They don't have standing to argue Lampron. They're not parties to this action. It appears the Commonwealth, who is the party to the action, has agreed that Lampron, the elements of Lampron have been met with our request insofar as it is concerned, specifically and addressed to Michael Proctor, Trooper Michael Proctor, and his communications with Jennifer McCabe, Elizabeth Proctor's communications with Jennifer McCabe, Jennifer McCabe's communications, counter communications with Elizabeth Proctor, and Michael Proctor's communications with Brian Albert and Nicole Albert. I'll address the issues that counsel raised in his moving papers on behalf of Elizabeth Proctor because that's the only writing that I have to go on at this point. He basically argued that there are false statements made about Michael Proctor's relationship with some of these other parties. Since the very beginning, and that brings up the fundamental issue, Your Honor, of what is that relationship and what's the nature of the relationship and why do we believe that that relationship establishes extrinsic evidence of bias and an inability to be neutral. From the very beginning of this case, we have questioned the neutrality and the bias of Michael Proctor and certain other government witnesses based on overwhelming facts that we've learned, overwhelming facts that establish that both this investigator and this investigation are compromised. That's why we've asked for the communications that the Commonwealth has now agreed with. Our request is nothing short of critical to our defense, obviously, and it's based on Ms. Reed's constitutional right as established in Davis versus Alaska, the U.S. Supreme Court constitutional right that's recognized as the right to attack the credibility of any government witness, be they a government witness on behalf of the police and the investigation or any other government witness.
Is Elizabeth Proctor a government witness?
She is not, but Jennifer McCabe is. And the communications that we're interested in are the communications that are concomitant between Elizabeth Proctor and Jennifer McCabe. We've established that there is a close personal relationship between and among Michael Proctor and obviously Elizabeth Proctor. That's the relationship and that's the foundation of our request. This is so important that I'll bring it back to the court's attention, and the court knows this, that even the sitting DA, the elected DA, decided to weigh in on this issue of the relationship between the Proctors and the McCabes and or the Alberts. And he said there's no such relationship, zero. This doesn't exist. As a matter of fact, the word that he used was it's a lie. Any suggestion to the contrary that there's any kind of relationship between the Proctors and the McCabes or the Proctors and the Alberts is a lie. His words. So the DA himself has put Trooper Proctor's neutrality at issue, and he did it in the most public way possible, and I would suggest a clumsy way. Who was he talking to? He didn't come into this courthouse and address the court, as we've all done. He didn't address the court, he didn't address the Commonwealth, he is the Commonwealth, he didn't address us, the defense. What he did do is he addressed the public and the potential jurors, and that was by design. So he calls the evidence that we've procured and that we've presented to the court as lies. Well, let's look at those lies for a quick second. We have presented the court with photographic evidence, not something that we came up with, something they came up with. Photographs in Exhibit C in our moving papers. And I'll just cover a couple of those. There's a photograph that we presented that shows Trooper Proctor's mother, the person by the name of Colin Albert, pictured in the photograph, with Trooper Proctor's sister pictured in the photograph, with Chris Albert pictured in the photograph, and with Jennifer McCabe's own daughter depicted in the photograph. They're all together at a birthday party. These are close and immediate family members of the Proctor family, the Albert family, and the McCabe family, and they're all together. And it's unassailable evidence of that relationship. There's a second photograph of Trooper Proctor and Colin Albert in a wedding party together. And I would urge the court to note, they're not at a wedding together. They're in a wedding together, in the wedding party. This relationship, as the court just noted, and I was about to get to in a second, is not just days old, months old, weeks old. This relationship is decades old between these families. There's another photograph that the court has seen, Trooper Proctor literally on the dance floor with Colin Albert. So when counsel for Elizabeth Proctor suggests, oh no, these relationships, you can't believe any of this stuff, just because someone happens to be at the same event does not thereby establish a relationship. They weren't just at the same event. They're in a wedding party together. They're standing on the dance floor, side by side, shoulder to shoulder, Trooper Proctor and Colin Albert. And then we see a photograph of all of them seated at the same dining room table. They shared a meal together. This is socializing. These are interpersonal relationships, and they can't change that. Trooper Proctor was seated at the same table having dinner with Colin Albert, Chris Albert, and Chris Albert's wife, Julie. Then there's the Facebook post, and I will leave it at this. I'm not going to go through the entirety of my motion, but I would highlight the last point that I think should be highlighted for the court's attention, and that's the Facebook post. Trooper Proctor's mother refers to the Albert family as the Proctor's second family. So one might actually ask Mr. Morrissey, who's actually lying in this case? Is it us? We just presented the court with factual information that was procured off of social media that it's unassailable. It cannot be assailed. And the Proctors have known these people for, as the court just mentioned, by asking for that date, for more than a decade. They've socialized with him, and his family considers their family to be so close and interconnected that they are deemed a second family to the Proctors. And who exactly are members of this Albert family and or McCabe family? Let's look at those members. Brian Albert, Nicole Albert, who is Jennifer McCabe's sister, Brian Albert Jr., Brian and Nicole's son, Caitlin Albert, Brian and Nicole's daughter, Jennifer McCabe, Nicole Albert's sister, Matt McCabe, Brian Albert's brother-in-law, Chris Albert, Brian Albert's brother, Julie Albert, Brian Albert's sister-in-law, and Colin Albert, Chris and Julie Albert's son. The McCabes and Alberts ostensibly are one family. They socialize within the same social circle and the same familial circle, and that is who the Proctors have proclaimed to be their second family. And if that weren't enough, we find out during the pendency of this case on September 25th, 2023, that one of those family members, Jennifer McCabe, who's the subject of great interest in this case and a primary person of interest in this case, is invited to Trooper Proctor's personal home for some sort of off-the-books meeting. Do we know about this meeting? Because Trooper Proctor, upon learning this, that Jennifer McCabe was coming to his house, ran back to the office and filed a police report, a supplemental report explaining this meeting, this off-the-books meeting. No, he never disclosed it. We found out about this because a concerned citizen happened to photograph Jennifer McCabe's car parked outside Michael and Elizabeth Proctor's personal residence in the evening after hours. And the best that counsel for Elizabeth Proctor can muster in terms of an argument is to say, well, you know what, Your Honor, maybe he wasn't home. Maybe, or maybe not. Certainly his car was there. Elizabeth Proctor's car was there, and Jennifer McCabe's car was there. Was Trooper Proctor home? I guess I would answer that by investigation in the middle of this crime was secretly meeting and or socializing with the lead investigator and or his wife in the living room of their home. And that, Your Honor, is a problem. And it shows more than a professional connection. It shows a personal connection. And according to the Proctor, the Proctor family's own counsel, Elizabeth Proctor's counsel, about this case. They weren't talking about sports. They weren't talking about the weather. They were meeting about this case. So how does that not show a bias, and how does that not implicate Karen Reed's constitutional rights to this information? And to this day, the Commonwealth has yet to concede what obviously is now sort of front page news, that there is in fact a personal relationship between the Proctors and their second family, the Albert McCabe family. But here's what the Commonwealth has said, even though they haven't made that connection or that concession. On October 3rd, 2022, Mr. Lally made a couple of points, eloquent points in this courtroom. And what he was doing when he did it in October was illustrating what an inappropriate relationship would look like if one existed, what a conflict of interest would look like if one existed. And he said, quote, Michael Proctor has been fully vetted, end quote. He said there's no conflict of interest here because it's not like, quote, these people are socializing together, end quote. He said it's not like, quote, these people know each other, end quote. And he went on to say it's not like, quote, these are people that Trooper Proctor has been over to their home, end quote. The Commonwealth said that because these facts would surely illustrate a conflict of interest. They would surely illustrate an undeniable bias. And those comments, Your Honor, I would suggest have not aged well. And I would wonder at this point if the Commonwealth hasn't adjusted its stance, which is why the Commonwealth is now conceding that we're entitled to these communications. And that turns on the question of asking, how could Trooper Proctor be expected to adequately and honestly investigate this case as the lead investigator? And also, who should be suspects in John O'Keefe's murder? And the answer is he cannot. And since the authorities, including Michael Morrissey, apparently have vouched for Trooper Proctor, my client, our client, Ms. Reed, is entitled to question and to test that voucher. And that's what we're seeking to do with the communications between Elizabeth Proctor and Jennifer McCabe. And insofar as that request is concerned, it's unquestionable that there are privacy interests at play, but I would suggest the following: that the constitutional due process rights of any criminal defendant in any criminal case hold a paramount significance because they form the very backbone of the justice system that this court presides over. And protecting those rights, such as the right to a fair trial, such as Ms. Reed's right to the presumption of innocence, that ensures an equitable trial and an equitable process. And while privacy rights of Elizabeth Proctor, a third-party witness, are obviously an element of concern and consideration for the court, they must yield to the imperative of a fair trial. And that imperative means Ms. Reed's ability to confront and properly cross-examine all witnesses, including Jennifer McCabe, including attacking the credibility of government witnesses, including Jennifer McCabe, based on bias, and that is fundamental to our justice system. So striking this balance ultimately upholds the integrity of the very system that this court is making sure exists and continues throughout the process of this trial. Elizabeth Proctor's privacy rights, while they exist, especially in light of the narrow focus of our request, are vastly outweighed by our client's right to a fair trial. And with that, Your Honor, I'll submit.
All right, thank you. Mr. Lally, are we going to hear first from counsel for Ms. Proctor, counsel for Ms. McCabe? I got an appearance this morning of counsel for the troopers as well. Counsel for the troopers going to address us?
No, Your Honor, that's in
Okay.
reference to another motion.
Okay, so I will hear counsel for Ms. Proctor.
This is not a balancing test between the defendant's right to a fair trial, which is obviously constitutionally protected and paramount to our system, and Elizabeth Proctor's privacy rights. This is a request to bring evidence before this court for the purpose of trial under the mechanism of Rule 17 that is not within the framework of Rule 17. And I'm sure the court has had the opportunity to review our papers. Our sole basis of an objection is not Ms. Proctor's privacy rights. That is obviously a paramount concern to any third party. And the interest in not being harassed or brought into a criminal matter or a civil matter that that individual has no involvement in is obviously of interest to anyone. But as it relates to the standard here, the question is whether the defendant's request satisfies the 4 prongs of Lampron. and the basis of Rule 17. And the defendant's request, I would submit to the court, fails on 3 of those 4 prongs. And I'm not going to belabor the facts underlying this whole situation. My brother laid out his case. That is laid out quite clearly in his affidavit as well. What I would say about the facts is, with regard to the first prong of admissibility and relevance, while hearsay that is reliable is certainly sufficient as a basis for a subpoena to issue, hearsay which is not a basis for a subpoena to issue. And in this case, my brother's affidavit essentially amounts to a large collection of conjecture and allegations which are not supported. With regard to the motion and the opposition that I filed, I appended an affidavit that lays out the basis for why I assert what I assert in my affidavit. And that's essentially conversations with individuals who have personal knowledge of where Michael Proctor was on the night of September 25th, 2023, individuals who have personal knowledge of the connections between, as my brother says, these 2 families, and who have personal knowledge relating to the actual photograph that my brother didn't mention in Exhibit C of his affidavit of Michael Proctor with 2 children who are still minors, who are not children of Jennifer McCabe. Essentially, the relationship between these 2, quote, families is a distant connection that involves 5 separate steps of relationships between, I guess I'll call them relatives. Chris Albert, not Brian Albert. And so what brought these different families to a wedding in 2012 was the fact that Mr. Proctor's sister, or Elizabeth Proctor's sister-in-law, was getting married, had her friend at her wedding, and her friend's sister and her family also wound up attending that wedding. The fact that Colin Albert and Michael Proctor were in the same wedding party, I think, is mitigated somewhat by the fact that Colin Albert was about 10 years old at the time and served as a ring bearer because he was a child. So the connections that my brother tries to lay out in his affidavit, I would suggest, are not what that affidavit makes it seem. Regardless of all of that, there's still issues on admissibility and relevance under the first prong of Lampron. And the reason for that is the defense actually includes a description of this September 25th meeting between Elizabeth Proctor and Jennifer McCabe, and why that meeting occurred, in a state police report that it actually appends to its motion. And whether or not a court down the road agrees that that area of testimony is valid grounds for exploration for impeachment of Ms. McCabe, what's occurring here is that the defense is attempting to use that as a basis to go get another layer of even more extrinsic evidence on the hope that something that's in the phone of an unrelated third party might impeach Ms. McCabe in an area that is already potentially a grounds of extrinsic evidence for impeachment. And that is not what is permitted under Rule 17. That is a hope, that is a conjecture, and that is not the purpose of the rule. And I'm not going to belabor the point for the court because I know the court is very familiar with Rule 17, but the purpose of the rule is to bring into the court for inspection and for purposes of trial records which are going to be admitted or are likely to be admitted at trial. It is not for discovery. It is not for exploration. Whether or not that exploration the defense believes is part of its case or not. It's a question of, are those records going to be admitted at trial, and do we know they exist? And the defendant hasn't made out any of those factors at this point. The defendant is essentially assuming that there are records, does not know what is in those records, and as a basis is requesting. And that is not a Rule 17 motion, that's a discovery motion. And with regard to that kind of last prong of Lampron, I think the defendant makes clear her basis for the request in counsel's affidavit, as I cite in my opposition. And that's thus the communication surrounding this, parentheses, and other meetings, which again, the defendant has no basis to believe there might even be other meetings, close parentheses, may reveal information necessitating further pretrial motions, including a motion to dismiss based on extraordinary governmental misconduct. And that's the purpose of this Rule 17 motion, but that's not the purpose of Rule 17. The purpose of Rule 17 is to bring into court relevant and admissible records. These records are not relevant to an issue in this case. They would not be admissible under any rule of evidence. And based on what's actually asserted by my brother in his affidavit, nothing about that assertion meets the rule of Rule 17, meets the requirements of Rule 17. The fact that communications may reveal information right off the bat fails. And the fact that they are looking for these records as they might necessitate further pretrial motions, including a motion to dismiss, is entirely anathema to Rule 17, which is designed to bring records into the court for purpose of trial. And so, based on all of those and what I lay out in my papers, I would ask the court to deny the motion.
All right, thank you very much. Mr. Reddington? To add anything to that, sir?
No, Your Honor. What I would do is basically, as I indicated in the motion, is join in on the motion. Noting the objection of Jennifer McCabe, obviously asserting her privacy rights, obviously suggesting, as counsel just did, that this is a clever maneuver to try to kind of weaponize Rule 17 to turn it into a discovery motion. We all know that the September 25 meeting was about harassment and what these two women had been going through on the news media with the extreme harassment that they were suffering as a result of their being witnesses on a case and cooperating with the government's prosecution of Ms. Reed. So I suggest to the court that comments like the records may reveal and they possibly would show, which is what's in the motions that's before the court, clearly shows that there's no basis, there's no factual basis to determine that these are relevant material records other than speculating that they may reveal. Just like the allegations that the photograph of the two young kids would be Jennifer McCabe's daughters, and they're not. And it's so frustrating to the McCabe's and everybody else because they know whose kids these are. The parents know that they're their children, but nevertheless, they consistently this is evidence of extraordinary governmental misconduct, which is a wild accusation to be making at this point. And I suggest to the court that weaponizing Rule 17 is not proper. I join in the government's request initially objecting. And the fact that the counsel has indicated that the government basically concedes and assents and does not oppose, should not interfere with Your Honor's analysis of Rule 17 as opposed to any Rule 14 or any discovery motions that would be appropriate before the court. Thank you.
All right. Thank you very much. Do you want to respond, Mr. Jackson, before I hear briefly from the Commonwealth?
Very, very briefly. Your Honor, I would simply, to the microphone, I would simply note as to my brother's arguments, eloquent as they may be, they missed the mark. Obviously, this is relevant and admissible. Again, I don't believe that Elizabeth Proctor has standing in the court to actually argue Lampron, but since it was brought up and since that seems to be the foundation of her argument, I do want to address one point. There's a case that was cited by my brother in his moving papers called U.S. versus Abel. It's found at 469 U.S. 45. It's a 1984 case. It does not stand for the proposition that is propounded in the paperwork. Indeed, that is a federal case, not a state court case. That's the first line of distinction. Second of all, it is a mischaracterization of the holding in Abel to say that the scope of impeachment is the outer limits. The scope of impeachment is limited to the outer limit that the scope of impeachment is limited to, quote, taking the witness at the witness's word or taking the answer of the witness, end quote. But rather, the court specifically held that it's permissible to impeach a witness by showing his or her bias. And that's all we're seeking to do. In the court's words, Justice Rehnquist's words, quote, a successful showing of bias on the part of a witness would have a tendency to make the facts to which the witness testifies less probable in the eyes of the jury than it would be without such testimony. That's found at page 51. Contrary to counsel's misunderstanding of the holding of Abel, our impeachment of this witness is not limited to taking Jennifer McCabe's word for it. We're entitled to extrinsic evidence about her bias, about her lack of neutrality, about her attacking her credibility. This evidence is clearly relevant, it's clearly admissible, and the Commonwealth concedes as much in its opposition paperwork. And with that, I'll submit.
Mr. Kettle, did you need to respond in any way? Okay, sure.
So I'm not going to debate Abel because the court can certainly read the case. But essentially, it's the defendant's burden to meet Lampron. The defendant bears the burden to get the court to issue a subpoena and has to show all four of those factors. And it's not about whether the Commonwealth objects or does not object, and whether I have standing beyond an issue of privacy or not, which I would argue that a third party whose records are being sought certainly does. It's a question of whether they have met those elements, and they have not.
All right. Mr. Reddington, did you need to add anything to that?
No, Your Honor, I'm good. Thank you.
Okay. All right. Does the Commonwealth want to argue this in any way?
Just briefly, Your Honor.
Okay.
Commonwealth is not opposing. The Commonwealth, however, does not assent, does not concede anything as it relates to any sort of relationship or whatever is being termed as a close personal relationship. The relationship, as the Commonwealth understands it, between essentially Trooper Proctor and Ms. McCabe is that Trooper Proctor has a sister who has a friend, who has a sister, who has a husband, who has a brother, who has a wife, who has a sister, who is Jennifer McCabe. And it's such a close personal relationship that after apparently scouring social media, there are exactly 0 photos that counsel has produced of Ms. McCabe and Trooper Proctor pictured together at any point in time. And essentially what you have to establish this close personal relationship is a wedding party from a decade ago and some photographs of Trooper Proctor with children purported to be Ms. McCabe's children, which are not Ms. McCabe's children. But given the limited scope of what is being asked for, the Commonwealth is not opposing the motion, but would obviously request that if the court were to allow the motion, that both sides would have equal access to inspect and copy whatever screenshots are then provided by the record holders, that being the third-party witnesses. Thank you.
All right. I'll take this under advisement. Mr. Reddington, you're free to leave, but thank you for attending. You're free to stay too, but all right. So now we'll do the motion regarding the Commonwealth's motion for protective order pertaining to the DNA profiles of the investigating law enforcement officers. So I'll hear from the Commonwealth first, then I will hear from counsel for the officers, and then I'll hear the defendant's opposition. Who's arguing this for the defense?
I will be, Your Honor.
Okay. All right, I will hear you, Mr. Lally.
So, Your Honor, just to clarify on this, just a point I think may be misconstrued based on the defendant's opposition. This is not a situation in which these troopers have consented to anything at this point. The purpose of filing the motion was to try to gain some guidance from the court as to how mechanisms would be concerned with the collection of DNA, the retention of DNA, the destruction of DNA, and the timing in regard to that prior to obtaining either Trooper Proctor or Sergeant Buchanan's consent in relation to the taking of any bugle swab. So how this sort of arises is there is a DNA report in relation to the taillight of the defendant's vehicle. There are 3 possible contributors to that DNA mixture. One is positively identified as that of the victim, John O'Keefe. 2 others are unknown. There's been rampant sort of speculation, accusations levied against these particular troopers in regard to contaminating evidence or planting evidence and things of that nature. So the exploration of this is sort of caused by that, in the sense of the Commonwealth believes that whatever DNA comes back, it would exclude those 2 troopers as being contributors to the unknown sources of DNA. So what the Commonwealth is seeking, and the reason that the Commonwealth actually filed another motion asking for sort of an expedited response from the defendant, is the hope of the Commonwealth, especially with March 12th jury trial day looming, was my hope was that there would be some sort of agreement that could be come to and a joint proposal to be presented to the court so the court could act on the papers, and this testing could be well underway, if not already completed, by the time that we reached today's court date. That unfortunately was not what happened. So we received the response earlier this week from the defendant. Essentially, most of the proposals that are included within the defendant's opposition are the precise alternative proposals as far as the protocol as the Commonwealth had laid it out. So as far as the defense not wishing for anybody associated with the state lab or state police to be collecting the sample, that's fine. We had proposed Ms. Christina Owens simply because she's a civilian member of the Crime Scene Services section. But if it, as long as it's a certified collector, it doesn't have to be anybody associated with that. The defendant has some issue with the state police crime lab conducting any of the testing, whether that be generating the sample or doing the comparative testing, and seems to be fine with that process proceeding at Bodie and Lorton, Virginia, where some other testing related to this case is already being done. That's fine with the Commonwealth as well. Obviously, that's going to prolong things a little bit, I would submit.
Do we know that?
I mean, what I can say is that our office would certainly be inclined to pay whatever additional fees would be necessary to expedite that testing. But as far as the time frame is concerned, I really can't say exactly how. Sort of point of contention is the defendant's ability or access to the actual sample. That is something I would object to. As far particularly in this case, I don't think there's really going to be any question that the samples or the profile that's generated is the profile of the individual troopers. It's going to be collected by an independent certified collector. It's going to be the DNA profile will be generated at an independent lab. The comparative analysis will be generated at an independent lab, and counsel would certainly have access to those DNA profiles should the defendant wish to, compare it to any other types of, any other pieces of evidence or any other, DNA that either they recovered during their evidence inspection or that was collected by the state police in regard to their investigation. So the need for the actual sample, I'm not really sure where that comes from, and the suggestion that the Commonwealth would have more access to it than the defendant would. especially if the court is inclined to go with the alternative suggestions of the independent collector, the independent generation of the profile, and the independent comparative analysis. I really don't see what defendants' access to the samples does or lends to any sort of credulity to the testing or to any further testing that the defendant wishes to conduct. So as far as that, I think really the only other sort of disparity or sticking point is the retention. The Commonwealth had suggested the end of the trial process, the reason for that versus what the defendant is suggesting as far as the conclusion of the appellate process is obviously the close of the trial process has a much more definitive end frame to it as opposed to the appellate process that could go on for months and years, if not after. And given the limited nature for which the Commonwealth is seeking the consent of these troopers to conduct this DNA analysis, appellate process. There are other mechanisms I would suggest that the defendants, could avail themselves of should they have a need for, again, the profile would exist, sort of in perpetuity in their possession, at least until the end of the appellate process. And there are obviously far more mechanisms available today than there have been in previous years as to post-conviction discovery and obtaining further samples, things of that nature. So again, that was the reason for the suggestion for the end of the trial court process. Again, the purpose of this motion was to seek the court's guidance as to exactly what the parameters of that collection, retention, destruction, and all of that would be, so that that can be presented to the troopers so that they can make an intelligent decision as far as their consent is concerned.
If this were ordered to be done at the state lab, when would the results be in?
That, I think, especially given just prior turnaround time in relation to other testing that's been done in this case, at the state lab, I would hope that could be completed within 6-7 weeks, something like that, at the most.
Okay. Do you want me to hear from Ms. Lundgren now or after? I mean, this is your motion. Do you want me to hear from her now?
I think that's fine as far as the order's concerned.
Okay.
Gretchen Lundgren, Your Honor.
Good morning.
Good morning, Your Honor. Thank you for hearing from me on behalf of Sergeant Buchanan, Trooper Proctor, in a discussion as their privacy interests as it relates to the Commonwealth's motion for a protective order. The proposed protective order strikes a balance between protecting the sensitive and personal DNA information of two individuals who are not alleged to have had anything to do with the death of John O'Keefe, while giving all parties access to the resulting scientific DNA analysis. The defense's opposition casts the proposed protective order as allowing the Commonwealth to obtain, test, and analyze the samples without giving them the same opportunity, but that's simply not the case. Both parties are willing to have an independent lab develop the DNA profile and conduct the comparative analysis. Both parties will receive the same reports and underlying data. Once an independent lab develops the DNA profiles, Your Honor, there should be no need for anybody to have access to the sample thereafter. And with an independent lab conducting the comparative analysis, there should be no need for anyone to have to conduct further testing. And finally, Your Honor, once the trial is over, there should be no need for those DNA materials to be on file. And as Mr. Lowry said, the legislature has provided a mechanism for obtaining third-party DNA post-conviction. So there's certainly a safety net there if the DNA is needed post-trial. Your Honor, protecting the troopers' DNA samples and profiles through these procedures and protocols poses no violations of the Commonwealth's mandatory discovery obligations. The Commonwealth and the defense would be on equal footing with regard to the troopers' DNA evidence. Each party is free to argue the implication of the results at trial as they see fit. As Your Honor, integrity of their handling of the taillight evidence. In order to provide consent knowingly and voluntarily, they're looking for certainty surrounding who has access to their DNA, how their DNA is handled, and ultimately how their DNA is disposed of. On behalf of my clients, Your Honor, I respectfully request that you issue the protective order proposed by the Commonwealth.
All right, thank you very much. Mr. Yannetti, it sounds, when I read your opposition, I did not know that there was this much agreement. Did you when you filed it?
I did not, and quite frankly, hearing the argument from both counsel, I think there's even more agreement than I anticipated.
Okay.
Your Honor.
What do you disagree with?
Okay, so our position, Your Honor, is at this point, with regard to the DNA samples versus the DNA profiles.
So where are you in your opposition? What page?
So I'm actually going to the Commonwealth's motion itself with regard to how the DNA samples and profiles will be treated.
Okay.
We did not realize that the Commonwealth was drawing a distinction between the actual samples themselves and the profiles that were generated. It was our understanding that the Commonwealth was seeking to prohibit the defense from having access to either. But I've just
but they're not.
Exactly. I've heard Mr. Lally say today that they will turn over the profile to us. That satisfies us.
Okay, I have a question for you.
Yes.
Since you mentioned Bodie Laboratories, you're the first one that mentions it in the pleadings. How long will it take?
We're not the first ones that mentioned it. The Commonwealth mentioned it in their motion, and we agreed to that.
All right, I don't have that.
Your Honor, it is one of the alternatives that the Commonwealth had. I'm sorry, I can find
Okay,
them.
so we need to find the paper number. All right, but we need to know how quickly that can be done, and we need to see about expediting it.
Typical for Bodie, just because I've recently gone through that with regard to the hair sample.
Right.
It's, I think, like a 12 to 14 week turnaround without any sort of expedition. So, you know, expediting, I don't know that necessarily that can be cut in half, but it is something that I think can be turned around a little bit quicker than their typical turnaround time.
And Ms. Lundgren, you'll have your clients available, you know, at the drop of a hat to provide this sample? All right, so go ahead, Mr. Yannetti.
Thank you. So, Your Honor, I think the only real conflict at this point, if the Commonwealth is holding to their motion, is their paragraph 7, which states the defendant is not permitted to conduct independent analysis or testing with either Sergeant Buchnick's or Trooper Proctor's DNA samples or profiles. Now, clearly, we won't do that with regard to the samples because we won't have them. We don't need them. But we will have the DNA profiles, Your Honor. And once we do, they, in my view, in my client's view, we should be able to use them for any case-related purpose. We have no interest in, you know, distributing them anywhere or doing anything with them.
Hold on, Ms. Lundgren, I think you should answer this. Why don't you come on up? Is there an opposition to that?
I just need you in front of a microphone. There's one right here. Thank you.
She could take this mic if she likes.
No, because we'll be going back and forth, so you should stay there.
There is an opposition, Your Honor. I mean, I think perhaps the Commonwealth can speak to it. I think there's also a strategic decision, a case-related decision. Certainly, we agree with the privacy interests that the troopers are providing their DNA for a specific reason and with regard to a specific item in this case. And they do want to limit that consent. However, that is more, I believe, a case-related and strategic reason that I would also defer to the Commonwealth to speak to.
All right, I'll hear from Mr. Lally afterwards. Go ahead. No, not now. I'll hear from Ms. Giannetti to finish.
Right. So there is other evidence in this case where comparative testing, DNA testing could be done. And in addition, Your Honor, I want to make it clear that our investigation has been ongoing and is ongoing to this day. We may come into possession of evidence related to this case, physical evidence, that we may want to do our own comparative testing on. And once those profiles are released, assuming that there's consent and that the Commonwealth comes into possession of a DNA profile, and the defense does as well by Mr. Lally's admission today, that should be evidence that either side can use for any proper purpose that is capable. DNA profiles if it relates to the case.
What do you want to say, Mr. Lally? We're talking hypotheticals here,
We are.
right?
So what I would say is the only other identified evidence really, or the bulk of it as far as DNA is concerned, concerns Mr. O'Keefe's clothing, which I don't understand what any relevance that would have pertaining to the troopers' DNA profiles. As it pertains to what ifs, as far as any sort of other physical evidence that counsel would come into possession to, the protective order, while somewhat ironclad, is not necessarily cement. So if there's a request for a modification based on subsequent evidence or something like that, I think that's something that the court can obviously entertain at that point. But really, the purpose of this is with reference to that one specific item.
It does make sense that if there is something later, you come before me on it.
Well,
So that's why I asked you if it's hypothetical. If you have an item that you want to test, I think the Commonwealth has every right to know what that item is.
okay, our position would be that we should be able to conduct our own investigation in private and reveal the results of those investigations, of that investigation, should we desire to. We have a different ethical duty than the Commonwealth. Clearly, if there's any evidence that the Commonwealth possesses that we'd like to do comparative testing on, we have no choice but to notify the Commonwealth and resolve any disputes before this court. But if we come into possession of anything that we believe is related to this case and should be tested, we don't believe that's any business of the Commonwealth to interject in that. We will have the profile at that point. We can do our own testing and then reveal the results of that testing should we desire to.
All right. Does the Commonwealth want to be heard?
No, Your Honor.
All right.
Maybe we have just a quick second, Your Honor.
Yep.
Yeah, my co-counsel brings up a good point, which is after Mark appeared at the Norfolk County DA's office on December 1st of 2023 with our forensic DNA collection expert, and he did swabbings of multiple pieces of evidence. So we do have those in our possession.
All right. I had no.
Separate issues. There are the items that we've swabbed that we should be able to test, and if we have the DNA profiles of these troopers, there should be nothing prohibiting us from testing them. And by the way, the Commonwealth has the ability to do the exact same testing on their own. And then if there's any other evidence, I still maintain that we should be able to do comparative testing on that as well.
All right. Let's get the samples going. Let's do that, and I'll figure out the rest of this. But let's get who do you have in mind for an independent collector?
Your Honor, I don't have anyone specific in mind, but most local police departments have at least someone who is a detective who is a certified collector. Is there someone the defendant? The two of you work out something.
I don't have any issue with working out something with Mr. Lally.
All right, so let's do it today.
That sounds good.
All right, and Ms. Lundgren, you'll make your witnesses available immediately?
Yes, Your Honor, but I just, for sake of clarification, just trying to understand, and as Mr. Lally said, they have not provided their consent yet. They are waiting to
Okay.
hear what the boundaries of the proposed protective order will be in order to provide that, knowing and voluntary consent.
Okay.
So, I mean, we could certainly potentially do the samples and hold them in abeyance and not release them if the court was willing to have them destroyed should the troopers decide not to provide consent based on the bounds of the protective order. But certainly, I think they do need to know what those terms are before moving forward.
All right. I need to look at this. I'll do it as quickly as I can. All right. Is that it on this?
Yes, Your Honor. On this
All right.
motion, yes.
All right. So the third and the fourth motion are sort of in their own category. So the third motion is, it's interesting in that I received the opposition, or the opposition to motion for protective order was filed before the motion for protective order, as I had it in the docket. Who's arguing this for the defendant?
This is the protective order regarding the letters, Your Honor?
Yes.
I will be arguing.
All right. So what I can say, Mr. Yannetti, is that it appears that you served counsel for the Commonwealth with this motion, but you did not serve the U.S. Attorney's Office. So the U.S. Attorney's Office has a right to be heard on this order, on this proposal that you have. So I need them here. I need them served. So you can serve them and we'll get a date.
That's fine, Your Honor.
All right, and we'll do it as soon as possible. I do not want to change the trial date in this case. This case will go to trial on March 12th. And the fourth motion, where I said the third and the fourth are sort of in the same category, the Commonwealth's motion for records from Boston Magazine, that needs to be appropriately served and have someone here from Boston Magazine if they oppose it.
Yes.
So I'd like to do this as soon as possible. And given our trial schedule and the fact that I intend that we try this case in March, like everybody served for a hearing here on January 18th at 3 o'clock in the afternoon. It's a Thursday afternoon. So it's just about 2 weeks. Should give you enough time if you serve these people today to get them here.
Can you do it?
We can do it via Zoom where it's
Your Honor,
discrete issues, yes.
we're in trial on January 18th. It's a short trial. Is there any other day that might work for the court?
I don't see any time that we can.
Is the 16th at all possible?
No.
No, no,
Oh, that's right on the back of the holiday, isn't it?
We're both supposed,
I understand that. No, it's not available. We start a trial Monday.
we're both supposed to be in trial that day.
All right, so you can do it via Zoom, or Mr. Yannetti can do it.
I can certainly do it. There's no chance of the 23rd, Your Honor?
Forward with that. I'm more concerned about that one, getting that one rolling
Understood.
than the other one, all right? So January 18th at 3 o'clock. All right. Anything else we need to talk about? Doesn't appear to be.
Your Honor, I think it makes sense to raise this one issue, which is today was the filing deadline for all non-evidentiary motions.
Right, and none have been for evidentiary motions. Today was the filing deadline for evidentiary motions to suppress, things like that.
I understand. So the defense will be filing before the end of business today, not evidentiary motions, but non-evidentiary motions one motion to dismiss and one motion for sanctions and also for disqualification recommendation of the Norfolk County DA's office from this case. So,
All right, so you were not filing motions to suppress?
Correct.
So they're being waived?
correct.
All evidentiary motions are waived?
Correct. Well, yeah, we'll have pretrial motions in limine. I don't know if they would,
Okay, but everything else, so,
but in
okay.
terms of constitutional issues.
So file them by the end of today, and if we can hear them on that date, we'll do that on the 18th.
Right, and that would, depend on Mr. Lally's ability to respond, et cetera, which, I understand he may need some time, but they will be filed today.
Okay. All right, thank you all.
Your Honor, there's several I apologize. Your Honor, there's several housekeeping matters I wanted to address with the court. In regards to the motions to dismiss that Mr. Yannetti, my brother, just discussed, we do have a motion to dismiss the indictments in this case, and I wanted to lodge the grand jury minutes with the court. They are very voluminous. I wanted to ask for the court's guidance on how you would prefer to receive those.
So when that happens, we typically get them on a flash drive, as well as, Jimmy, how are they filed with you?
Counsel have filed by email and then followed up with the grand jury minutes. So they can do it by thumb drive.
All right, so a thumb drive, but get a separate one for
We'll
me.
mail that to you so that you'll have the hard copy, the thumb drive. The other housekeeping issue I wanted to address with the court, Your Honor, is, as you know, the court has ordered the Verizon records relating to Jennifer McCabe, as well as the Google Nest records. We were informed by the clerk's office those were supposed to be produced to the court on December 15th. My understanding is you guys have not received anything, and I wanted to follow up on that because that obviously is evidence that we hope to have in advance of trial.
All right, so Mr. Clerk, is your office call or is counsel call?
I've never called.
Yeah. So typically defense counsel calls and says there's a court order, where are these records?
I emailed the clerk's office and they said that they haven't received anything yet. And so that's why I wanted.
Right, so call Verizon and call, who's the other record holder?
Google Nest.
Contact the record holder and say there's a court order, where are these records?
Okay, but
Okay.
you all have not received anything.
I don't know. Jim?
Yes, no, I'm thinking.
Have you received them?
Could counsel come to sidebar?
Okay.
Absolutely.
Free can't read, free turtle boy.
That's it.
Your Honor, if I may, just one last thing, just with regard to the motion to dismiss, as far as does the court want the exhibits that were presented to the grand jury in addition to the minutes, or just the minutes?
Yes, I assume where you say it's so voluminous, it's the exhibits as well, Ms. Little?
I can produce.
You have to stand in Massachusetts. Thank
Yes,
you.
I can produce the exhibits as well.
Okay. All right, so everything.
And I don't have a problem providing that to the court as well. I don't want to duplicate matters, but
Okay.
if it's easier, I can do it. It's fine.
So those would obviously be provided under seal, Your Honor, with.
Of course, they're grand jury minutes.
Correct. That's with regard to the motion to dismiss, the basis of which is the grand jury presentation. The separate
Is it
motion,
McCarthy or Odell?
both.
Okay.
With regard to the second motion for sanctions, Your Honor, the letters that were the issue of the protective order that the Commonwealth moved for, that we've now put off, those will be part of the quote unquote evidence with regard to the motion for sanctions. It's our position, obviously, that those are not exempt from public disclosure. However,
I'm going to keep them exempt until we hear from the U.S. Attorney's Office.
that's why I raised the issue, Your Honor. I just wanted
Was
to.
that your suggestion as well, so we could get moving with this motion to dismiss?
Of
Okay.
course. Thank
All
you.
right. All right. Thank you.
Thank you, Your Honor.
Court will rise, please.
All right, so- Thank you.
So we're going to go to the DA's office now tomorrow.
You are muted.
To get your.
That's not the point. The point is, I've never seen a circus like this. There have been 110 murders or more.
You can go ahead, yeah.
I've been part of. I've never seen anything that's a quarter of this. It's bananas. Grindeder, I sat watching Dr. Grindeder kill his wife in 1999. Had $1 billion defense. Mike's on.
What I would say is just go there, check in the front desk, ask for Lieutenant Tully, he knows you're coming.
Hey guys, not much to report today on this. I didn't find this hearing to be particularly interesting or all that revealing. The stuff about trying to get at Elizabeth Proctor's phone is a pure fishing expedition. I've seen some of the communications between Elizabeth and Jennifer McCabe. They didn't know each other before what went on this summer. They met actually at the office of the DA when they went to complain about the harassment that they were suffering under the Turtle Mob. And that's when they met, and they kind of developed a friendship because they were both in the same situation of having their families kind of tortured by this. I think it was a bad idea, and I said that at the time, for them to get together during this case. But if anything, the fact that they got together is really evidence that there is no conspiracy, because if you can imagine two families that are involved in a bank robbery, and then it's under and then meanwhile they're under investigation and the spotlight is on them. If you're involved in a criminal activity like that, you would know, stay the hell away from each other until the trial is over and until the headlights, the spotlights are on. They didn't do that, so it's really the fact that they got together is more of a sign that there's no conspiracy than anything else. But they still shouldn't have done it because the optics weren't good. And they should have understood that the turtle riders are out there everywhere, taking pictures, digging dirt, making up shit. So they should have been more aware of that, and they should have had better judgment, I think, although I understand why they developed a connection. And it's just an unfortunate part of this case that a mob has been created, and these families are being attacked. And it's much more than just a matter of, it's the pursuit of justice we all agree with, and nobody gives the state or or any state or any prosecutors or any police the benefit of the doubt. I certainly don't. I've seen enough abuse in my life, my own experiences, but also in studying true crime cases to definitely, let me just turn this down. I don't think there's anything else coming back on, but I'll keep it open in case something comes back on, but I think they were done for the day. To me, it's a fishing expedition, and there's nothing they're going to find on those communications. They know that, but the thing is there's nothing useful they're going to find in terms of the trial. But but a huge part of this case now has become the public trial, the little things that they can exploit. So you can take that little off phrase, and then Alan Jackson can re-describe it, and everybody can get all riled up. For example, the non-human hair, which is ridiculous. It's not. There was no non-human hair found on the bumper, but he was perfectly happy to take that and misdescribe it and make it seem like it was something suspicious. There's no gap in the library video. Videos don't record that way anymore. This isn't 1991 where things are recording continuously. The video is motion triggered, and nothing drove by at that time to trigger a recording, and that's all it was. Now you might say, why didn't Lally explain that at the time? And I was upset by it too, but I understand better now. The reason is they, under discovery, they're required to share all the evidence they have. Each side is going to share it with the other side. So they're required to give all the video evidence that they have to the defense. However, they are not required to give any analysis or to describe what they're seeing. So if they have a piece of video that shows an SUV that drives by some location that looks suspiciously like Karen's, they're not required to give this and say, aha, there's Karen going by at 12:41. They're not required to do that. So it's up to the defense to figure out what they're looking at and what they're going to talk about at the trial. So this is why they don't want to tip their hand during these motions. So the state, Lally, they're holding all that stuff in check until the trial, and they want to keep the defense guessing as to what they're interpreting this evidence. So that's important to keep in mind. It was interesting in this hearing to see that the defense is planning to file motions for the DA to recuse himself, or his office to recuse, but that stuff's not going to go anywhere. It was very unusual that the DA came out and made that statement this past September. And as soon as that happened, I think we all looked at that and said, wow, the defense is definitely going to try to exploit this somehow. But they're not going to get, the Supreme Judicial Court is not going to order, or Judge Canone is not going to order this out of the DA's office or into some other independent hands. There is not, unless the feds have uncovered something, but apparently if they have, they haven't released it to anybody. They haven't sent it to the state. So there's literally no evidence of any corruption here. There's certainly no evidence of any corruption involved with DA Morrissey. I don't work for Morrissey. I've been critical of him in the past on this channel. Like, for instance, the accident that he was in several years back. It seems supposedly it was a 5-car accident that he was at fault for, and supposedly he had some kind of a medical episode and his blood alcohol tested 0. I'm a little suspicious about that. Is he powerful enough to make sure that blood test comes back 0? Maybe he is. I don't know. Maybe I have a suspicious mind sometimes. But in this case here, there's literally nothing suspicious about the conduct of his office. And even the defense's focus on Proctor. I mean, Proctor was outranked by Buchanan, who was outranked by Lieutenant Tully. And there's no reason to think that those guys have any connection to anything going on here, or any reason. There's no motive for any kind of corruption involved here. It doesn't involve a state police trooper, this crime, any of this stuff. So, I mean, it's just, I think these guys, it was just a routine, in hindsight, maybe it would have been better off, even though the connections between Michael Proctor and any of these families is thin. there's a connection. I think either Michael or his wife knows, or their family knows, Chris Albert's wife. That's it. And that's why, that's why they were at the same wedding 10 years ago. And that's all they've been able to find. So there's not some close connection here. But still, the fact that Michael Proctor is from Canton might have been enough that they probably should have got somebody else involved in this case. And I'm sure they probably all feel that way now. I'm sure Michael Proctor is like, damn, I wish they had just, my number didn't come up that day. But I think they just looked at this case as routine, and they weren't looking at this case and thinking about a wild conspiracy theory that was going to be dredged up and promoted to the public through a blogger. Maybe they should be anticipating. And I think in the future, people will anticipate that kind of thing. But I don't think that they were anticipating that. And so that explains some of what went on here. For me, I don't believe that the troopers' investigation should be above judgment or critical analysis. I should say the troopers, because it wasn't like Michael Proctor was the one guy running this investigation. But, in fairness, he can't defend himself right now, so he can't explain why things were done in the sequence they were done, or why reports were made a certain way. He won't be able to answer that until later. I'm not even, he'll be questioned by the defense attorneys, so he may have a chance to explain, hopefully, some of that stuff at trial. But even it's possible that you never can fully explain it, or given that chance, because until after he retires, right? Because he does work in a position where you just kind of have to have thick skin and do your job. But it kind of sucks because in a case like this, it's more than just your skin; it's your wife's skin that's being attacked. And so I think, but these are a lot of things that look strange. That, for instance, that Olivia point out really aren't that strange, and we'll get a better explanation for them at the trial. For instance, she's made a big deal about the documentation of the subsequent pieces of taillight plastic that were found in the days after the initial investigation. And personally, I would say, like as I've said, the fact that she knows about them and that we know about them means they were documented. Now, I don't know if proper procedure was followed or not. I'm not a cop. I'm not an investigator. Are they supposed to? So you had enough taillight pieces to make the case, but then as snow is melting over subsequent days, you get reports, or you come out and you find another little piece or something like that. So you pick it up and you throw it in your evidence bag. Are you supposed to, each time as the snow is melting, if each time you find a piece, is this like spent shell casings? You're supposed to get out the CERT team and put a little flag there and document exactly where it was found? I don't know. But to me, it's not really suspicious that wasn't done. It's more like, all right, we're just putting this in the evidence bag, and I'm documenting. If it would be, if he didn't document it, if he just threw it in the evidence bag and never reported that these were found on subsequent days, well, maybe that would be more suspicious. But the fact that he did document that when they were found, I don't see it. There's no there. There's just nothing really suspicious to look at, And, I'm going to, unfortunately, I have to pay attention to block these guys all the time. But this has become, to me, this case is now bigger in many ways than just Karen Reed. It's bigger. The justice for John is obviously, nobody has faced a higher price than John and his family. But the reason this is bigger is because what has been created now, this mob and the mob tactics that they use, is going to last. If we don't stop it now, it's going to outlast this case. And let's not pretend that the mob doesn't exist. Let's be clear. If someone has legitimate questions about this case and they don't trust the state's position on it, that doesn't mean they're in the mob. So plenty of very intelligent, even people like, say, Wayne, who I've had on my channel, a former federal retired ATF agent, he thinks there's a lot of odd things about the case. He doesn't think there's a conspiracy, but some things bother him. Obviously, this is a very intelligent, well-grounded, capable man. So there's nothing wrong with having questions about this case. It's healthy. That's not the mob. But the mob exists when anybody else who doesn't agree with them, the first step is for these people to go find whatever they can do to silence that person. So they're gonna, if they can find something in their past, if they can find an embarrassing photo, they go, and it's not just Turtle Boy encourages it because he's done this for a long time. I wasn't aware of it, but I've learned in the history of it now. This is something that they've been doing for a long time, and they all do it, including, I'll just give their initials, people like J.A. I've seen the communications. It's part of their plan. It's part of their strategy. Go out and dig dirt and try to silence people. Now, the First Amendment doesn't technically apply to the issue of trying to silence people through social media, but still, if you value the First Amendment because you prize free speech, how do you feel about a mob that is trying to silence people, silence their free speech? I mean, I have a lot of messages from people from, I don't say a lot, but I have I have messages from people within the media that are afraid to kind of step out on this because they don't want to take on the crazy mob. Because the reality is I'm kind of in a unique position that I'm in a little bit of a boring Boy Scout for my life, and I don't really have anything embarrassing in my past. Despite all the people trying to make stuff up and say that there's nothing actually in my past, so I knew I could step forward. But a lot of very good people do have things in their past, and this mob will use it, so it keeps them silent. So you have a lot of very intelligent people that should be part of this debate and this discussion on this case, and they are silenced because this mob wants to keep them silenced by looking into their background, by by creating images and a collection of information on them that they can use to control them. And make no mistake, they do it consciously. They do it. You can see some of it if you just really look between the lines on Turtle's shows, but it comes through in messages and stuff. I've seen enough now. It definitely is a real thing. And so if you want to support that mob, understand that you're supporting those tactics. You're supporting the effort to try to silence people that disagree, people that are just not out. You don't see me out there trying to attack families or smear anybody. You might say, for instance, all right, so Lauren De Laguna was on earlier posting in chat, and she mentioned that she thinks that I slandered her by wondering if she was Olivia, who's someone that comments on frequently on Twitter. Now, I certainly would have no reason to ever want to slander Lauren. I don't know her personally. I made a connection because I had seen Lauren in the spring going on certain shows with Turtle Boy about this case. And I thought she was very effective and articulate and intelligent. And, she brought something to the debate. And then Olivia is someone that pops up all of a sudden over the last few months, or kind of seemingly around the time that Lauren disappeared. So Olivia popped up on Twitter, and she also is making a lot of very articulate, intelligent points. And so I made a possible connection. You had two intelligent people. One seemed to disappear around the time that the other one became part of the debate. But if she says and they say that they are not the same person, I believe them. So so I'm sure they're not the same person. I'm 98% sure that Lauren is not Olivia. But I certainly meant no effort to smear her because they were both intelligent, articulate people. So and it's, in terms of even Olivia's anonymity, I generally respect the idea that people should be allowed to discuss this case and remain anonymous, because you get jackasses like Short Bus Steve that are making threats and stuff like that. So it is something that I respect that idea. But if I have speculated on who she was, it's because she seems to be much more than just somebody that's interested in the case. There's an appearance of possibly inside information. Now that doesn't mean that she shouldn't be allowed to remain anonymous, but there is an area where you start to cross into where you're an advocate. And we do know that there are paid advocates for Karen in this case. I'm not going to get into specifics, but we know that that's a fact. And so I'm not saying that Olivia is one of those, but it is a legitimate thing to worry about when someone is spending all of their time promoting Karen Reed defense theories. They make no effort to ask any questions about the other side. So they're clearly just an advocate. Are they a paid advocate? I don't know that. But I think the combination of anonymity and this hard advocacy does make you wonder if there's a right to know who this person is. At least, I mean, when I'm making arguments on Twitter or anywhere else, I'm not hiding. You know who I am. Steve Cody can make threats to me. And also that guy, Jimmy Z, and some other people. But I'm not suggesting that she should have to be subjected to that. But if you're really hardcore advocacy, where you're preparing, you're looking at documents and you're preparing highlights and you're putting that stuff out there every day, and you seem to have some inside information, I don't know. Is there a public interest in wanting to know who that person is? I don't know. I think it's an interesting debate, and people can discuss it. I actually really don't know what the answer is. I mean, Olivia has been polite and intelligent, commenting on my channel all along. I watched her for the first time on Dave's show a couple weeks ago, and I thought, seems like a nice person, polite, has real interest in this case. So I don't know who she is. So I don't want to see anybody. I don't want to see anybody attack her, slander her, or anything like that either. I mean, because we all have a right to have an opinion in the case, and that's and really the goal here, the whole purpose of doing true crime channel analysis. So, for instance, I've had this discussion with Kate because Kate kind of thinks that people should just really back off and let the system do its thing. Because none of us, and there's a reasonable case for that, because none of us is a trial lawyer. Most of us that are participating in this discussion here, we're not lawyers. We're not police. We've never done a murder investigation. So we're just learning about what is going on, but we're also very ignorant about a lot of aspects of this case. Just all of us. I mean, and that's just a fact. So there is a case to be made for just letting the system do its thing, because mistakes are made, or in this case here, more than just mistakes, you have the ability of a defense to use a blogger to stir things up with a lot of misinformation and things that are improperly explained as to what they are. And so there is a danger to it. But I also do believe that there's a role for public analysis of this, because in the time that I've studied true crime, it's just amazing how many times the police screw up the investigation. I've seen a lot of examples where the prosecution is corrupt, I would say, where they ignore exculpatory evidence. It's not that they're being corrupt and they're being bought off, but they are so committed to wins and losses that they are willing to break the rules. And most of the time when that happens, there are no sanctions. They're not charged with a crime. And so there are a fair amount of innocent people that do get convicted and go to jail. So I do think there's a role for the public and keeping their feet to the fire. And I think it also helps us and learning more by having these channels and these discussions to learn more about the process of the law and of these investigations. But it's tough. I mean, I don't disagree with Kate. I just kind of on both sides of it. I do think there's a role for it here. Just the cases that I've looked at. I mean, I believe, so last year we looked a lot into the Kohlberger case. And I think actually the investigators did a fantastic job in catching Brian. And they really they seem to have run that investigation by the book, and it's a credit to law enforcement in cases like that. where they just do a really good job. However, even in that case, there was the spokesman for the Moscow, Idaho police. I forget his name, but he made a lot of statements that had to be withdrawn because they were absurd. And they were even trying to suggest that there was no danger to the public when nobody knew that. And one of the cases that I've covered extensively on this channel, and my friend Dave McGrath has covered extensively in his book, and we did some documentary footage with Melanie McGoughlin, formerly Melanie Perkins, in Lawrence. This was the Andy Puglisi case. And I was 10 years old when Andy went missing when he was 10. I didn't know Andy, but I lived about a mile away. And there was a big deal. I mean, the National Guard was called in and there were helicopters overhead all the time. I mean, I remember it very clearly as a 10-year-old. And, where was Andy? And he went missing, presumably abducted over by a public pool that was near the projects. And there was a wooded area behind that pool near the highway and this river. And he went missing. And 6 days after this, and the public was on edge. I can remember, all of as kids, our parents being on edge and keeping kids in the house. And so there was a lot of pressure on the police. And the police, they want to not only solve the case, obviously, but they want to allay the public fear. So they put out a story that was the headline 6 days afterwards, that there's nothing to worry about. It basically, we believe that Andy is safe somewhere with family. And so every big collective sigh of relief went out of the whole city. You could almost hear it, right? I mean, and life went on and everybody forgot about Andy. Until a few years later, when he was still missing, other people would bring it back to light, and they brought in psychics and searches were done, but they never found him. But I can say that I found out, and a lot of it was through Melanie's work, that there were multiple pedophiles, predator pedophiles, that were around that pool that day, and someone eventually went to jail for other things and explained what they did in Lawrence in terms of hunting kids. And some of the areas that they were hunting for kids were, at that time, I was playing baseball and things like that. And we had no idea what the danger was out there that was lurking. And that's because, the police, by then they knew and they didn't tell us, and they misled the public. Now, I'm not saying that they would have caught Andy's killer. Had they not done that, I'm not saying that. It's really hard to say, but so again, I unfortunately, I just got a message from a family member. I'm not always paying attention to chat here, that people keep posting my address here. Now, why? It's because I'm giving you analysis that you don't like. And so you want to threaten me by posting my address here. This is what I mean. This is why I'm not going to back down, because this mob, and let's just name all the people in it, all the henchmen: Susan Arundel, Jen Albert, not Jen Albert, Jen Altman. These people are disgusting human beings, okay? Because they are participating in this in this attempt to try to silence debate, to try to create threats on other people. It's disgusting. You're lowlifes. That's what you are. You think you're fighting for justice. You're not. You're lowlifes, and I'm not going to back down to you. And more other people are going to stand up to in this case here. We're not backing down to you pieces of shit, because that's what you are. You want to embarrass people. You've created this mob where this is what you want to do. You want to scare people into silence. It's disgusting. You're just disgusting human beings. I don't know how you even get up in the mirror and look at yourself. To get up and look in the mirror and just realize that I'm a low-life human being. My life isn't great, but at least I don't have to do that. You do. You have to look in the mirror and know that you are a piece of garbage. But I'm not afraid of you. Okay? I'm never going to back down from you. I'm never going to be afraid. All this really does is show what you are. Okay? And this is the crowd that you want to hang with. So anybody who wants to go down and hang around with Turtle Boy and his bullhorn, this is what you're a part of. This is not new. This has been going on for a long time. This case just made it bigger. Okay. But you're just nothing but pieces of garbage. That's what you are. And it's amazing that a lot of these people actually have strangely work in healthcare. I mean, I have nothing but the most enormous respect for nurses. And, you know, I've dealt with them a lot myself with my own healthcare, but certainly seen a lot with my mom, my dad, and just, you know, my mom just got out of the hospital, and the experience been really, really good. But a lot of nurses, for some reason, have latched onto this case. I showed one on my channel the other day, and I don't get it. Why do nurses think? Why do nurses? I know why they attracted to this case. Why they attracted to Turtle Boy, and why is it? I'm sorry, I have to keep. Why is it they people like Chrissy Young are out there just, you know, you're out there, you're part of this gang, and to think that you work in a hospital as a nurse. She works at Boston Medical Center, and people's lives are in your hand, and you're just a dirtbag that doesn't care about other people. That is part of these tactics. You're driving people around and you're spitting in driveways. How is it that you are working in healthcare? You can't possibly be capable of any human empathy if you're going in, for instance, into the driveway of Julie Albert. I'm sorry, Julie McKay. No, get the name wrong on. No, I'm sorry, Nagel. Julie Nagel. Julie Nagel, whose only crime is saying that she didn't see John walk into the house. That's it. That's her only crime in life. And so because of that, these people accuse her of being part of a murder conspiracy. She's a 23-year-old woman. She also was a nurse, I think. Oh, no, she's not a nurse, but one of the other, there's another 23-year-old woman, Levinson, that was in the house, who's also a nurse. And their only crime is telling the truth and just saying, I never saw John come in the house, which is the GPS shows that John never went in the house. The GPS is clear. John never went inside that house. Whatever you think happened outside, if there's some other theory as to how John got killed, okay, but it didn't happen in the house. Those women are not lying. But this nurse and her friend from the Boston Medical Center is driving around spitting in their driveway. How do they have jobs still? These aren't decent members of society. You know, I mean, it's just, you know, and obviously, like, I've had to ban this guy, Dave, who keeps putting up my address here. No matter how much I ban him, he keeps popping up there. But this tells you, because these guys, this is what they do. They create multiple accounts. I have one account. I have one YouTube channel. I have one Twitter account. Actually, I do have a few other older YouTube channels that I don't use, but I haven't logged into them in years. So, I mean, but these guys, their life is to create multiple accounts so they can go on and try to harass people, and it's just disgusting. You know who you are. Look in the mirror and understand that you're just dirtbags. But we're not going to back down from you, because we don't back down from pieces of shit. All right. I'm willing to take all evidence on this case. Is there any corruption going on? Is there anything unusual going on in the case? Yeah, I'm open to it. You know, but the GPS is the GPS, and John didn't go in the house. All right. So you're not going to be able to get around that in trial, and they're not really going to try to get around it because it's stupid. There's no way to get around that John didn't go in the house. There's no way to get around the fact that John was searching for 34 Fairview when they were in the car from over a mile away. You know exactly where they are. And that's a 3-minute drive. This is the time when so the defense says that he was going up and down stairs in the house. All right, stop, Kevin. If you, Kate says stop. If you are correct about the multiple accounts. Let me hear you deny that your cohorts are doing the same exact thing on Twitter and every place else. Come on, Kevin, be real. We won't expect Pulitzer Prize winning reporting from you, but we expect honesty. Maybe they do. I'm not part of it. I have no idea. I don't have any cohorts in this case. All right. So I think there's a tendency for some of these people, they think that the only way to fight fire is with fire. I don't agree with that. I think you have to try to stay above the, above board. And if you can't sink down to their level, but are people out there trying to threaten anybody on the other side, Kate? I don't see it. I mean, you tell me if that's true. I mean, here I am. I've never been anything but be respectful to people on this case, even people that disagree. All right, let's just put it to you, Kate. All right, are you still listening, Kate? I've got people on here multiple times under multiple accounts putting up my address and making threats and messaging me with threats. How do you feel about that? Is your reaction just to try to take on the other side? What's your feelings about that? Do you feel that I deserve to be threatened? Do you feel that? Do you feel that those tactics, do you think I'm the only one that gets that? Do you think I'm the only one that gets that treatment from this mob? Let's go. I'm waiting for you in the comments. Let's see what you had to say. You know, you're pretty quick to pull the trigger on me. So let's see what you have to say, though. You know. Blanca, is it Blanca or Bianca? Looks like it says Blanca. Says, me too. I am really here and Twitter. This internet world is insane. And it's a mind fuck that took me forever to figure it out. Hi, Julie. Thank you. No, I mean, obviously I don't, but I'm not going to, and I'm not going to back down to these people. All my life, I don't back down to bullies, and I am not backing down to these pieces of shit. And it obviously people, and I think I know who that Dave is too. That's that piece of garbage that's threatened me on Twitter before. I know who he is. Let me see. I could probably pull up here and find his name. And so that all you guys, I'm not going to hesitate to say his name because he threatened me on Twitter. Let's see if I can find it. I know his first name, so I'm looking to, if I see the second name, I'll know it. Let's try David. Yeah, there it is. David Alexander. Now, I don't know if that's the same Dave behind this Dave 25 and multiple related accounts, but he's made threats to me in the past. And I try to be nice to him. And he's a guy that apparently served his country in the war, and I respect that. He does some kind of a business now as a traveling bartender, like like a cater bartender, go do events. I respect that. But these people have turned this cause and this mob and this man, Turtle Boy, into their heroes, and they've attacked. Now, I don't know if this is the same Dave, but he's made threats to me in the past. And so if this is the same guy that keeps popping up under multiple different versions of Dave, this is what you're dealing with. A lot of these people are crazy. But this is, the mob embraces that. They want these crazy people. That's their weapons. That's their Luca Brazzis, and that's what, you're not going to back down. If you have the truth, you just tell it and let the chips fall where they may. And if I see other people being bullied, I'm not going to back down. I'm going to defend them too. I defended Elise Bennett. I didn't agree with the things that she was saying on her channel, but I agreed with her right to do it. And then when she was attacked by the mob, I defended her. And that's the way it has to be. I will defend anybody that's just going out there and giving their analysis and giving their opinion. They have the right to do it. And you might say, well, does that apply to, for instance, this guy we call the grifter? He calls himself the glarer. I call him the grifter. Well, yes, I would defend his right to his opinion. That doesn't mean I won't still say something to him to describe him as the grifter, because that's what he is. He has no interest in the truth here. He's just trying to go out there and ride a bandwagon and to pick up views. And that, unfortunately, that's where kind of most of the channels are on this. They just kind of want to grab views and they want to join the mob, and they're afraid to take on the mob. And there's money in it and there's popularity in it, and it is what it is. But I defend their right to do it. Absolutely. I defend their right to do it. So DeAndre likes the Luca Brasi reference. Yeah, I mean, I'm a big Godfather fan. I don't know if you guys, I've seen that. That's one of those movies I've seen 100,000 times, 100 times, you know, probably more. Embarrassingly, probably more. If I'm flicking through the channels and The Godfather is on, then I watch it. So now he's under as some guy named Dave doing it. So it's, you know, it is what it is, you know. So what is the idea of putting, you tell me, dirtbags, what is the idea of putting my address out there? Is it because you want someone to come to my house and threaten me? Is that what you want? Because you don't like what I'm saying? Is that what it is? Because I'm part of the McAlberts, the great McAlbert gang? Is that what you think? I mean, it's crazy, you know? And it really isn't about me, it's about you. This is what you are. And anybody who supports this, this is what they are. Okay? Frankly, if you give money to Turtle Boy's channel, you're contributing to that mob. Okay, because if you look in his chat, that they're all in there and they're all part of it, and he encourages those tactics. So if you want to be a subscriber to Turtle Boy, you're contributing to the mob tactics. And this is what needs to stop. Okay, this mob tactics of trying to silence anybody you disagree with, trying to threaten them, trying to dig dirt. They started on me. All I did was back in August ask questions about the case. I was on the fence and asking questions. And Turtle Boy was calling me a both sideser. That was at the time the big crime to him. And then when I said, well, listen, I'm a both sideser, but you're just an advocate. You work with the defense. And he lied and denied it, which we knew for a fact that he'd been working with him since April. And he lied to his audience. But as soon as I had that episode where I went after him, they immediately started trying to dig into my background, find out where I lived in the past and where I worked and all that stuff. That's what they do. They can't beat me in an argument. They can't beat integrity because they don't have any. They don't have any integrity. So they try to destroy you. It's what they do. Now, it's okay for you to ask questions about this case, but if you want to support people like that, you're part of the problem. Now, I do have to go because I have to go help out with something health related with a family member. But thank you guys. Have a very good day today, and I will see you all soon.